the so-called liberal values of our current secular regime that are pretty pervasive in a lot of institutions. They claim to want tolerance for diverse viewpoints, for these kind of liberal viewpoints, but they're coercive. They're not tolerant once they get into power, right? It's not enough for these people on this side of the abortion debate to say, well, those who agree with abortion should be able to perform abortions and kill innocent children in the womb. It's not that they're asking for tolerance that they do it. They're saying, well, if anybody disagrees in an institution that we now control, they're pushed out of the medical field altogether. We want them out. Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal. You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith-based nonprofit organizations. So this week, we'll be covering a shocking and very complicated federal district court decision in the seemingly never-ending battle of the Little Sisters of the Poor over the contraceptive mandates that's now been going on in one form or another for over a decade. Then we'll turn to the Eighth Circuit and discuss a case where the court upheld an Arkansas ban on transgender procedures for minors, which will sound familiar if you followed the Skrmetti decision that came from the Supreme Court regarding a similar law in Tennessee this past year. And then we'll finish up with a newly filed lawsuit from a Catholic medical student who was dismissed from the medical program she was in after voicing concerns when she was unexpectedly made to observe an abortion. So time is going to be tight to try to get through this Little Sisters of the Poor case, so let's get right to it. One caveat, this case is very difficult to make sense of. For one, it's been at the Supreme Court before. There are several rulings. What's going on in this district court is not just about the Little Sisters case, but about some other contraceptive mandate related cases like Burwell v. Hobby Lobby and the Zubik case. And so there's a lot going on. And if I'm going to try not to get too into the weeds, but some of the weeds are a little bit necessary to make sense of what the court just did this past week. So there's a lot to deal with here. I'm not an expert in this case or in its background. So if anybody listening is an expert or can find errors in some of the details here, I will not be offended. Reach out, let me know, and we will correct the record. So with that, let's dive in. This starts with Congress's passage in 2010 of the Women's Health Amendment to the Affordable Care Act. So this is an amendment to Obamacare, and the amendment delegated authority to an administrative agency to determine what drugs and what medical procedures insurance providers would be required to cover under the Affordable Care Act. And that amendment added contraceptives as well as some abortifacients to the list of required items, which would trigger the now 10-year plus long battle with the sisters and basically 15 years of chaos fighting over these contraceptive and abortifacient requirements. So the rules that are at issue here came beginning in 2018 or so. Several executive agencies added what are now known as the religious rule and the moral rule. These were exemptions or expanded exemptions for organizations that had religious or other moral objections to providing contraceptives to their employees. So the Little Sisters of the Poor got involved because, of course, they would not be complicit in providing contraceptive and abortion coverage to their employees. So that case involving the Little Sisters reached the Supreme Court in 2020 and was decided in favor of the Sisters, Little Sisters of the Poor, as most listeners would remember. Despite that, kind of confusing if you're just looking at the headlines, a district court just recently vacated the religious and moral rules, forcing organizations, including the Little Sisters of the Poor, to either provide coverage for contraceptives or face the fines and other consequences of noncompliance with the Affordable Care Act. So what is going on here? Well, so the court here ruled that when promulgating the religious and moral rules, the agencies basically acted in a capricious and arbitrary manner. That's a legal standard under the Administrative Procedure Act. We'll get back to that later. And the district court here stated that despite citing the Federal Religious Freedom Restoration Act as justification for the exemptions in these rules, the agencies failed to provide sufficient rationale for the original 2018 additions to those exemptions. Attorneys from Beckett, who are representing the Little Sisters in this case, have already stated they plan to appeal this decision to the Third Circuit. Very possible that this will go back up to the Supreme Court again. So from the outset, do want to make it clear that this case or these similar issues have been decided by the Supreme Court. right? In 2020, the Supreme Court ruled on the Little Sisters of the Poor versus Pennsylvania, and we're specifically addressing whether the agencies that created the religious and moral rules via regulation had the authority to do so. So the Supreme Court voted 7-2 in an opinion written by Justice Thomas that the agencies did have the power to issue the religious and moral rules, and that these rules were not procedurally defective. So what's new that justified this district court vacating those same rules? Well, this is where we're going to have to get into some weeds, and then hopefully we'll be able to find our way back out. So, of course, the district court has to acknowledge the 2020 Supreme Court ruling, but what it points out is, well, several things. But what's basically at issue here is the district court points out that the earlier case never decided whether the religious and moral rules violated the Administrative Procedure Act by being arbitrary and capricious. They were deciding other things about these rules, and this is where it gets murky. So the history is complicated, but let's try. The court basically goes through the last decade of history on this case, explains how these administrative rules were expanded to include not just religious nonprofits, but eligible corporations that could be for-profit. Hobby Lobby is one of the cases that weighed in on this, where for-profit closely held companies were allowed to take advantage of RFRA claims related to these contraceptive mandates because the owners had religious objections to providing contraception and abortifacients in their healthcare plans. So there was an accommodation. It was a self-certification process. Depending on the timeline of when you look at these, there were self-certifications either to the employer's health insurers or to the federal government, where you could basically say that, I object to this contraceptive coverage. And it was allowed so that the objecting employers could certify that, under RFRA, under their religious exercise rights, they could avoid the contraceptive mandate. Several parties actually objected to this, even as these accommodations were clarified and expanded, and this includes the Sisters of Life, the Little Sisters of the Poor. And they had said that, well, when we're self-certifying, or even when we're just notifying in a simpler way to the government that we object to the contraceptive mandate, what's then triggered is the federal government is basically made aware of this and then steps in, and it's the insurers, perhaps not the employers, who are still required to provide free contraceptives. So we'll probably swing back around to this, but the basic continuing objection is, listen, under our religious freedom exercise, by having to notify the government that we object to this, what's going to kick in is they're still going to get free contraceptive coverage, and that's our employees. This is still complicity in providing contraceptives and abortifacients. That's the argument. It's complicated. There was a case in 2016-17 called Zubik where this was brought up. The issue about the self-certification requirement and whether it violated RFRA was never quite resolved in that case. I don't really want to go much further into that issue, but basically that's part of what's going on here, is the court saying, well, this was never quite resolved. We're not even sure that the self-certification requirement itself is a substantial burden on religious exercise. Maybe the self-certification is enough, and that this rule goes above and beyond what's required by religious freedom, and that's where we're going to end up. So basically, the agencies, when all this was going on, were responding to cases like Hobby Lobby and Zubik. SCOTUS did determine that RFRA applied, at least for closely held for-profit organizations, and ultimately that there were less restrictive ways to provide contraceptive access without burdening the religious exercise of the employers here. So one thing that also comes up in this district court case is there's some disagreement among the justices about whether RFRA, the Religious Freedom Restoration Act, actually requires these expanded exemptions or whether it just allows these claims. Justice Alito opined that there's no compelling interest in providing free contraceptives from the government at all, and that therefore RFRA requires the agency's broad exemptions. Justice Kagan disagrees. She accepts that the rules were within the scope of the agency in the original 2020 case, within their authority, but she maintained that lower courts could in fact determine later that the rules were arbitrary and capricious under the Administrative Procedure Act. So again, I know there's a lot to swallow here, but this is where we end up. So the case was decided. It was noted that these rules, the religious and the moral rules, were not defective under the Administrative Procedure Act, and that they were good. But then the case returned to the lower court, and there was still this issue of whether the rules, even if they were enacted properly, whether they were arbitrary and capricious, right? So it goes back to the lower court. This case gets stayed when President Biden is elected. The new administration indicated they were going to amend these rules anyway, so this is put on pause. New rules were proposed by the Biden administration. They were commented on, debated, went through the whole notice and comment process in 2023 into 2024. The new rules would have limited the exemptions, would have ensured free access to contraceptives through the Affordable Care Act. But around the time President Trump was reelected, we're getting to late 2024, the proposed Biden rule in 2023 was actually withdrawn. So therefore, the original final religious and moral rules, the ones that were at issue the first time at the Supreme Court, did in fact remain in place. So then this whole case goes back to the lower court, who lifts the stay, and it says, okay, now we're going to decide whether these rules are arbitrary and capricious. So that's a lot of background. District Court has a 55-page opinion that came out. It'll be last week by the time you're listening to this. Many pages of it are dedicated to the case history, questions of who has standing to bring this suit. Around 30 pages in, we actually get to the conversation about the arbitrary and capricious review. Now, the way I read it, and I think the sane way to read it, the bar for arbitrary and capricious rulemaking, it's pretty high, right? A challenging party needs to show that the rulemaking agency fails to articulate a satisfactory explanation for its action, doesn't show a rational connection between the facts and the choices that the rulemaking agency made. So this is not an ability for courts to step in and second guess what rulemaking agencies are doing. If the rulemaking agency has Congress's approval to specify rules, then it really has to be over the top. Like there was no rational way that the facts that you're relying on justify this rule. That should be the standard. I know that's a paraphrase. That's not the strict wording, but that's the gist of it. So the argument in this case is that RFRA is the justification for these broad exemptions, right? Including the ability of organizations not to even self-certify or notify the government because it's a burden on their religious exercise to be at all complicit in the providing of contraceptives to employees. So the court argues here that the effect of this objection was an extension of the religious and moral rules, right? Allowing entities to refuse to provide contraceptive coverage without even notifying the government or filling out the self-certification, right? The agencies in the lawsuit argued that in theory, this would even cover publicly traded companies, right? That this burden on free exercise can extend to any party who meets the objection and doesn't want to fill out the self-certification, saying that would be complicity in the contraceptive procuring. So the court says that they rely on some dicta from Hobby Lobby. It was not part of the ruling, which said that, well, we're not talking about publicly traded companies, we're talking about closely held companies. So the court here is saying, well, the rule has now gone above and beyond. The agencies are saying that this even applies to publicly traded companies who are unlikely to ever raise a RFRA claim because they're publicly traded, right? They don't have like particular closely held owners who would raise a RFRA claim in the first place. And so basically they're starting to argue here that these rules are overbroad and basically we don't like them. So the district court makes several decisions here that I'm going to try to wrap up before I get too far off base or get myself in trouble. Again, very complicated. But what we come out with is the district court says, well, the rules made here are arbitrary and capricious. The religious rule, the justification is, well, the agencies identified a problem, right? A RFRA violation, a substantial burden on religious exercise, but then proposed a solution which the court argues is not rationally connected to solving that problem. By exempting organizations whose compliance with the accommodation, right, including publicly traded companies, would pose no real conflict with RFRA to begin with. And that's the gist of this argument. RFRA does not require the religious rule, the court says, because there's no substantial burden to religious exercise by self-certifying or notifying the government. So the argument here by the court is the connection between the action notifying the government of your objection and the provision of contraceptives are insufficiently related. Now, I think it's worth calling this out. That's not arbitrary and capricious. I think the court here is second guessing what the agency, I think, reasonably did, was say, okay, there's an argument here that religious employers object to notifying the government that, hey, we have an objection to the contraceptive mandate, because they know that notification is going to trigger free contraceptive coverage to all of their employees. So by self-certifying or by notifying the government, they're complicit in providing things that they find gravely immoral. to say that it's arbitrary and capricious to exempt religious employers from those notification and self-certifying provisions, I think that's a stretch, right? You could disagree with it. You could say, well, maybe the burden doesn't rise to the level of substantial, but that's a second guessing by the court of what the agency did here, if you ask me. And the other thing is the court says, well, and then regarding the moral rule, which goes beyond particular religious objections to moral scruples about providing contraception and abortifacients, court says, well, Congress didn't authorize agencies to create the moral rule in the first place. When contraceptives were added to the required care with the 2010 amendment, Congress never went back and amended the Affordable Care Act to include moral objections to contraceptives at all. And the court argues Congress never intended rulemaking agencies to add these kind of moral objections beyond religious objections. So a lot here. This is still very early on. I think it was a little shocking to people that we've had this case that had been stayed for 5 years. There was no new hearing. There was just Trump's back in office. That amended rule from the Biden administration never went through. And so we're going to go right back at it, lifted the stay. And all of a sudden we get this order 5 years later, where the court concludes by claiming that, I'm going to read from it, the agencies did not provide a satisfactory explanation for their action, and that they failed to provide a satisfactory explanation for their change in course regarding contraception's safety and efficacy, and they failed to adequately address reasonable alternatives to the rules they crafted. Again, this seems like quibbling with the outcome. It doesn't seem like it was arbitrary and capricious. It just seems like the court doesn't like the broad exemptions and the broad accommodation for religious liberty that the agencies came out with. So I would say that this just arbitrary and capricious is a stretch, to put it mildly. And one thing I do want to add, just because I think there will be some questions about this, because what just happened here is this district court got rid of executive agency action on contraceptive mandate exemptions for the whole country. So the question, of course, is, hey, Trump versus CASA, what about the ban on nationwide injunctions issued by district courts that we've heard so much about over the last few months? The district court, of course, has to acknowledge the Trump v. CASA case. It does so in like a paragraph near the end of its decision. I think it's on page 51 or 52 of the opinion. But the court holds that this is distinct. So in the case of arbitrary and capricious review of an agency action, courts are directed by precedent to set aside those agency actions. So what the court's basically saying here is it's vacating an agency action. It's a process called, well, the legal term would be vacatur. If you actually speak Latin, in English legalese, it's probably vacator, which hurts me to say. But when you're vacating an agency action, it's procedurally something different from a nationwide injunction of a law. And so what the court's saying here is, well, Trump v. CASA is inapplicable. This is about vacating agency action. It's not about a nationwide injunction. And so our ability to be a district court that can issue an opinion with nationwide ramifications is still legitimate. So a ton here. We expect this to go back up. As I said, it'll be interesting to see. The court does cite a bunch of Third Circuit precedent that makes me think that the Third Circuit's probably going to side with the district court here on the arbitrary and capricious holding. Although I'm not sure, the Third Circuit's makeup has changed. There have been a couple of new appointments here. It's not the same as it was when these cases came through, but we'll see. The poor little sisters may very well be going back to the Supreme Court with Beckett in the next year or so. Joseph, I have talked way too long on this case. And again, apologies to people for having to try to dive through, a decade of complicated procedure in 15 minutes or so. So please.
Yeah, so two things I'd want to add to kind of add some context. The first, towards the end there, you noted that the court concluded by saying that the agencies that added these rules failed to provide an explanation for their change in course regarding the safety and efficacy of contraceptives. And basically, part of the arbitrary and capricious standard that they're using to rule against this rule is that you have to provide, when you make a change in the rule, adequate justification for doing so. And in the original 2010 law, and then the rules were added shortly after, the agency that was originally responsible didn't say anything about there being concerns of the efficacy or safety of the various contraceptives that they added to the law. And then in the 2018 revisions, there were some comments about, in light of the concerns we have about their safety and efficacy, we're adding these exemptions as well. Not the biggest part of it, but it is important to note that that is part of the argument here. And there was a justification provided. They actually provided actual studies and scientific research, but that's a kind of smaller part of the argument. I do want to add some other notes about how the standard, so the arbitrary and capricious standard that the court is trying to apply here, seems to be actually way beyond the actual legal requirements, right? When you think about the plain meaning and text of the words arbitrary and capricious and of the kind of rational connection that's required underneath that, the problem is that RFRA was violated by the contraceptive mandate. And then the solution is, well, let's not apply the contraceptive mandate to the people whose rights would be violated. That seems to be neither arbitrary nor capricious, and it does seem rational, right? Here's a problem. This is the solution that would exactly solve the problem. It seems to make sense. The court relied largely on pretty non-existent precedent. You noted about how they cited the Hobby Lobby case, and where they talked about the publicly traded companies wouldn't really win under a RFRA claim. The end of that paragraph says, but we're not actually going to decide on that now. This is just kind of something we're observing. So that being the crux of the argument of a non-existent precedent also raises some red flags. Great, we'll move
it'll
into...
be interesting to see how this goes up, because I think Justice Kagan did signal in her 2020 Little Sisters concurrence that it may very well be that lower courts could find these rules arbitrary and capricious, but I would be surprised if the Supreme Court, if 5 justices on the court would buy this, that these rules were arbitrary and capricious, given everything we've just said, and especially your points at the end there. So let's leave it at that and discuss some other stuff.
Right. The next two are a bit more straightforward, so this won't be a 3-hour episode. So the second update is somewhat better news. The Eighth Circuit recently upheld Arkansas's ban on transgender medical interventions on minors. So those familiar with the podcast or with the Skrmetti case in general, a lot of this will probably sound pretty familiar. But there are 2 really big differences that we'll get into. So for some of the background, Arkansas in 2021 passed their Save Adolescents from Experimentation Act. Basically, this bans, very much like the Tennessee law, at question in Skrmetti, any doctor from prescribing, performing, or referring these various quote unquote transgender, like cross-sex hormones, actual surgical interventions, that sort of thing, where for minors only. So when a boy wants to identify as a girl, or vice versa, there are these medical interventions that are now illegal under Arkansas law to perform or refer. In response, a group of minors, parents and doctors filed a lawsuit. The main claim in that lawsuit is that this is a law that classifies based on sex, and because of that, it's subject to strict scrutiny, which most of these things fail. The ruling generally followed Skrmetti, so basically said that the actual classification being made here is age and medical procedure, not sex. We're not distinguishing on if this person is a boy or a girl. We're distinguishing on the type of medical care that is being given. Medical care, I use the term loosely when referring to transgender interventions, but the court basically said we made a classification based on age, one, because it's only applying to minors. And they said that it's a different type of medical procedure when you use these puberty blockers and that sorts of things for the purpose of change in sex, at least as perceived by the physical characteristics and that sort of thing. So they're not actually regulating anything that's making a classification based on the gender or sex of the person receiving it. They're making a classification based on the type of medical intervention in question. So moving into how this is different from Skrmetti, there's 2 big things. First, unlike the Tennessee law, Arkansas law bans referrals for these procedures. The Tennessee law just bans the procedures in the state. There's nothing about referrals, but here a doctor that refers, a boy who wants to identify as a girl from receiving a cross-sex hormone or a puberty blocker, they're not allowed to refer to them from an organization outside of Oklahoma either. This is a bit reminiscent of something we had talked about last week, where the Oklahoma governor signed an executive order that banned funding for nonprofit, or banned funding for abortion providers in the state, but it also banned, depending on how you read it, funding going to facilities that refer for abortions as well. So kind of a similar thing here, where this could have impacts beyond just Oklahoma, because referrals are also outlawed. And secondly, this is where I want to zoom in a little bit, because there were a few things that set some alarm bells off, but it's actually could be used really well in this case. So citing directly from the opinion, the court said that parents do not have an absolute right to make medical decisions for their children. Now, if you're like me, when you first hear and read that, it kind of sets off an alarm. Anytime the state says the parents don't have a right to do this and we have a right to do it, it can be a little bit, well, what are you actually going to be saying here? Um, but the way that this was applied was pretty narrow. It says basically, can a parent obtain a medical procedure for a minor that the state has deemed unsafe for children? And the court is saying in this instance, no. Um, they said that history and tradition show two things. For one, states can prohibit medical treatments for adults and children. That's kind of just playing from the history of the US law. And second, parents cannot automatically exempt their kids from regulations. They cited a few different cases about employment law and that sort of thing, but basically they're saying that when there is a law, parents can't just say, this law doesn't apply to my kid and I'm going to do what I want. So the upshot of that is, in this particular instance, the court does not find a deeply rooted right of parents to exempt their children from regulations specifically applied to prohibiting gender transition procedures. So if applied correctly in this narrow instance, it makes sense, right? If there's a law against transgender surgeries for kids, a parent just can't say, well, this law doesn't apply to me. But just in general, whenever that sort of thing gets brought up, I think it's important to mention and bring up, and it's really important to pay attention to how this logic gets applied in other cases.
Yeah, no, that's a good point. Couple things I'll just add quickly. One is you're right. I talked to a legal scholar on this recently who was a little bit concerned with where we might end up accidentally taking the parental rights thing, because at a certain point, and we've said this on this podcast before, I'll keep saying it, we are going to have to weigh in on laws that are good versus laws that are bad in accordance with human nature and the good of the human person, right? So there are things like mandating that elementary school kids go to pride parades and stuff that are bad, right? And so parental supremacy over the state in making their kids do bad things, absolutely, slam dunk. But there's a certain point at which you're right. Like the state exists to ensure that certain societal evils are prevented. I think like no question, mutilating minors is one of them. And so, yeah, parental rights are not unlimited. They're certainly not. Rights stem from duties. So you have the duty to raise and educate your child to be healthy and good. And so none of that requires that you mutilate your minor child. So it's very hard to talk about these distinctions without an actual like natural law understanding of what the good is, though. And so I think eventually like these legal battles are going to come to a head, where just asserting parental rights or the rights to do certain things over and against the state for the sake of freedom without an application of what is good is going to be a problem. And you pointed that out. And again, we recognize some of these things as legitimate, right? Like you can't waive the prohibition on like purchasing alcohol. You can't send your kid with a consent note saying that your 14-year-old actually can buy vodka from the liquor store, because there's just a regulation against kids buying it. If you're going to give it to your kid yourself, that's a different question. But you're right. If the regulation is there and it's legitimate and it's meant to protect children, there's generally not just a waiver right where a parent can override it, right? There are certain actions they can take, but not an automatic exemption, as you said. One thing I just wanted to point out, because I think this is relevant, there's an argument that the Eighth Circuit rejects in the opinion here that I think is important, because we see Bostock kind of trying to creep its way back in here. So we've talked about this before, right? The argument that upholds these laws, and to my mind, the ban on referring for these procedures is a distinction without a difference. This is still very much Skrmetti. This is a clear one. I don't think the Supreme Court's going to take this case, because I think it's essentially the same case as Skrmetti, and this is the end of it. If I had to predict. But the difference, right, is Skrmetti had said, there's no way to make this sex-based discrimination. As you said, Joseph, this is discrimination on the basis of age and medical procedure. Neither of those are suspect classes that warrant heightened scrutiny. So there's no equal protection or due process claim that's going to trigger higher scrutiny here, period. Whereas in Bostock, the unfortunate logic that Justice Gorsuch got us into, only for purposes of Title VII for now, but we're seeing them try to expand it, is that, well, no, in certain cases, this is sex discrimination. It's not about gender identity per se. You can make this about sex discrimination because, right, we know the famous hypothetical from Gorsuch. If a woman wants to wear a dress to go work at this employer, she is free to do so. It's part of the dress code. If a man holding the same position at the same employer wants to wear the same dress, he's not allowed to, therefore sex discrimination, right? The but-for difference is one's a man, one's a woman, sex discrimination. It's a problem for reasons that go beyond the scope of this episode. That's not what sex-based discrimination is supposed to mean in these employment discrimination contexts. But you can see it creeping, or you can see the attempt made to bring in the Bostock logic here in this Eighth Circuit case, where the minors challenging this law in Arkansas said, well, hey, a male minor cannot receive testosterone to masculinize his, can receive testosterone to, quote, masculinize his appearance, but a female minor in the same situation cannot take testosterone to masculinize her appearance. So you can see what's going on here. This is an attempt to use that same Bostock, well, but for the fact that it's a man or a woman, that's the only distinction. This is sex-based discrimination, right? This is what they're trying to do to trigger heightened scrutiny under the Equal Protection Clause. The problem here is they're being disingenuous because a male minor cannot, in fact, go to a clinic and just say, I want to appear more masculine, give me the testosterone. Like, that's not how that works. Testosterone can be prescribed for a male who has clinically low levels of testosterone and has certain medical conditions, not because he feels like looking more masculine, whereas, a female is banned from doing the same thing. It's just not the same thing. The analogous case would be if a female who's supposed to have X amount of testosterone to be healthy, right, which is much lower than a male level, is medically deficient in what a normal biological woman would have, then maybe we're talking about something legitimate. But this is just not a good faith argument. Like, you don't have the right to just go in and demand testosterone because you don't think you look masculine enough if you're a man, but not a woman. So I just want people to be on their guard and be aware that opponents of these laws are going to do everything they can to try to turn these into sex-based discrimination claims, which they are not. And then the other thing to look out for is there's also going to eventually be a case where age is not the issue and where there's going to be a question of whether transgender status is a protected class under the Equal Protection Clause. We don't yet know what all 9 justices think on that. So I'm sure we have a couple cases coming up, but I think we'll see an adult ban on transgender surgery, and then we'll get to the bottom of that question in a future case. So with that, let's finish up with a pretty straightforward case that we wanted to highlight for a couple of reasons. So there's a Catholic medical student. I hope I'm not butchering the name. Her name, she's an Indian of Indian descent. Her last name is Thopurathu, I believe. So she's was a student at Springfield College's physician assistant program. Part of that program is to complete 11 clinical residencies in order to graduate. She did very well. The student received a 92% on her first 5 rotations. She was sent to an OBGYN office for her next rotation. When she completed that rotation, she was asked for her feedback by the program. She recalled her overwhelming experience of having to observe an abortion. She was told she was not informed beforehand what the procedure would entail. She said she wished she was asked prior to being assigned to this case if she was comfortable with seeing a D&E, which I guess is a form of abortion. She voiced her concern. The administration started to take antagonistic steps. They, put her on leave. They ultimately dismissed her from the program. The student, who is an Indian, who is also of Indian descent and is also a Catholic, recently sued the school, which does receive federal government funding. That's relevant here. There are several claims in the case, including discrimination based on religion and national origin under Title VI of the Civil Rights Act. So after her objection to abortion, based on her religious and cultural beliefs, were made known to the school dismissed her for, and this is their quote, having personal values incompatible with those of the administration. First of all, there are many legal theories going on in this complaint. She sues under contract-related violations, right? Alleging that the school breached its contract. They took a lot of money from her. They were unjustly enriched by taking her tuition and housing dollars and then dismissing her toward the second half of the program here for reasons unrelated to her performance. But also relevantly for our interest and our purposes, she sued for religious and national origin discrimination under Title VI. And what she claims in the complaint is when the student expressed her concern with being exposed to this abortion procedure without notice, she was dismissed for having values inconsistent with the institution. And her argument is that, well, my values come from me being a Catholic and an Indian. Like we don't believe in abortion. I'm opposed to this both for religious and ancestral reasons. And so you dismissing me for incompatible values, you're discriminating against me for my values that are based on my religion and my national origin. That's a clear violation of Title VI. Fascinating case. I think first it's an example of what we've discussed many times on this podcast before. The so-called liberal values of our current secular regime that are pretty pervasive in a lot of institutions. They claim to want tolerance for diverse viewpoints, for these kind of liberal viewpoints, but they're coercive. They're not tolerant once they get into power, right? It's not enough for these people on this side of the abortion debate to say, well, those who agree with abortion should be able to perform abortions and kill innocent children in the womb. It's not that they're asking for tolerance that they do it. They're saying, well, if anybody disagrees in an institution that we now control, they're pushed out of the medical field altogether. We want them out. They don't have values consistent with ours. So much for liberal, diverse values strengthening our society. They don't want Catholics who are opposed to abortions involved in the medical profession, it would seem, or in public discourse at all. Second, I would just say, I think it's heartening to see the Civil Rights Act used for what I would consider its intended purpose, preventing actual discrimination based on the characteristics that are actually laid out in the Civil Rights Act. So Ms. Thoparathu has Catholic and Indian values. She was told that she may not participate in a federally funded program because her values differ from the values of the institution. To me, I mean, that's impermissible. That's the viewpoint-based discrimination that's not allowed based on these protected classes, right? It's religious discrimination. It's arguably national descent discrimination. Although I'll be interested to see how that plays out, whether you can make the case that it's an Indian value and she's being discriminated against for being Indian because Indians are against abortion. But be that as it may, I look forward to following the case and hope to see Ms. Thoparathu successful in holding the school accountable. I know she's asked for a lot of money in damages for being dismissed from this program.
Yeah, so I want to add a few comments about what the school is actually doing, because it helps to have a bit of a face of what this discriminatory activity actually entailed, because it was more than just kicking it out from the program. There were a lot of things before this, and they just kind of kept ramping up more and more until they finally just said you can't be a student anymore. Also, towards the end of her residency, so this was like, I think she completed all 11 plus one residencies at the end. So this is at the very end. But basically, for the breach of conduct claim, there's a student handbook that everyone had to sign. They had to do 11 rotations and everything. Like I just mentioned, they forced her to do a 12th rotation because they said she failed that 6th rotation, even though she originally received a passing grade. So the person observing her gave her like a 80-something%, which under their handbook was a passing grade. And then later they said, oh, actually, you failed this one, so you have to spend more time at school. And they also subjected her to some undefined academic probation, also nowhere in the handbook. They just kind of threw that out there. There's an incident where after she voiced her concerns, she was encouraged to take a leave of absence due to quote unquote anxiety that the school saw her in her. And during her approved leave, she asked to be exempt from an event, and then she was denied, even though they told her to take leave. So it was just kind of this escalating series of events and antagonistic, clear tone against her after her beliefs. And after her dismissal, she even appealed and submitted a 120 or so page. And in the dismissal, it was clear that they didn't even actually read her statements. She was given no actual reason why her appeal was denied. So it was beyond just a mere dismissal. There were a lot of different things that the school did that only came into place after she voiced her concerns against being forced to watch this abortion with no prior notice.
All right. Well, I think with that, we will wrap up and just thank our listeners for joining us for this episode of the Napa Legal Podcast. If you enjoy the content we're putting out, we always appreciate it if you like the podcast, subscribe to our channel on YouTube or Spotify or wherever you're listening from. If you want to support the work that we're doing, you can always donate at the Napa Legal website, and we appreciate your support. We hope you'll join us next week as we continue to highlight and discuss some of the most important ongoing legal issues that affect religious liberty, and particularly the work of faith-based nonprofit organizations. We'll talk to you next week. Thank you for joining us, and God bless you all.